Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have been reporting on the lawsuit that was filed by the families of the four students who were so tragically lost at 1122 King Road on November 13th, 2022, brought against Washington State University. The lawsuit was originally filed in Saget County in Washington, a state court, and it brought a number of claims against the defendant WSU, beginning with count 1, a federal statute, Title IX, alleging violations of that statute. There's also been state claims for negligence and wrongful unaliving. What Washington State University did is, per a federal statute known as a removal statute, took the case out of state court and brought it into federal court. And when that happens, it has to be in the district, typically, where the state lawsuit was filed. So in other words, the state lawsuit was filed in Saget County, which is in the western part of Washington. When the matter was removed, Washington State University removed it to that part of the federal district court system that serves the western part of Washington State. In other words, it was not removed to the eastern district. It was removed to the Western District, Seattle Division. The university then, on the 30th of January, filed a notice to change the venue, a motion asking the federal court in the Western District to take the case, transfer it to the Eastern District of Washington. There's a couple of district courts that are located a lot closer to Pullman, which is where the main campus is located and where a lot of the events that the complaint addresses took place. The hearing on that matter is scheduled to occur on the 27th of February. We've checked the docket this morning. There has not yet been a response from the plaintiffs to see if they agree or disagree with this transfer. If they agree, it will be a lot easier to get this case moved. If they disagree, then the court will have to look at both sides' arguments and determine whether it is properly maintained where it is in the Seattle division or transferred to another division of the state closer to Pullman. Another issue that the public has been asking questions is, where is the response to the lawsuit by WSU? Well, in looking at the docket this morning, that also has not yet been filed. The matters are now governed by the federal rules of civil procedure and the local rules of the federal court. And according to the federal rules of civil procedure, there is a timeline when the defense must file or risk potentially default, and also what they can file. There's actually two rules. One rule says that if the defense was served with process, in other words, if the plaintiff had to go through the time and the expense to get the complaint, get the summons, and serve it upon WSU, then it's 21 days from the time that service of process was effectuated. But there is a rule for the federal rules of civil procedure that attempts to try to mitigate the costs of litigation in federal court, which can really get to be very, very high, by saying, look, plaintiff, you can go to the defense and ask them if they would waive formal service of process and maybe do it through an email, or what's in the rule is through the U.S. mail. So if that happens, and it's a plaintiff's decision to do that, the plaintiff would approach the defense, say, look, we want to try to mitigate the costs of this proceeding, which we're going to ask for you to reimburse us if we're successful at trial, and if you decide to informally be served, i.e., through the U.S. mail, then you get more time to respond to the complaint. So really, everything is based on when did service of process actually happen. And there's nothing in the federal court that's been filed explaining when that happened. The other matter that the federal rules govern is what type of a responsive pleading or motion can be filed. In other words, the defense has an option to decide, are we going to go ahead and answer this lawsuit with a formal answer and raise our defenses? And that's where any counterclaims and third-party defendants can be brought in with pleading. Or do they want to take another route? Do they see a problem, a defect? Sometimes defendants will look at the complaint and it could be shotgun pleading, where there might be 150 different allegations and 20 different counts, and everything applies to everything. The federal courts require that the allegations be specified to what specific count you're raising. Otherwise, it could be subject to a motion to dismiss. Other times, they might file a motion to dismiss for something else, failed to state a cause of action upon which relief may be granted. Or they could ask for a more definite statement. These are all responsive motions that are filed in lieu of an answer. So we're going to continue to monitor the docket to see when WSU's responsive pleading or defensive motion is filed. And at that time, we will go ahead and, of course, notify you. And at this time, what I wanted to do is just thank you all very much for your incredible support of our content. It means a lot to me to be members of the channel, as you all are. It is something that is very much appreciated by me. So I want to thank you for that. If you have any comments, opinions, thoughts that you would like to share relative to this matter, please leave them here. And until next time, this is Kathy. Thank you for joining us here today.